Hello there. Hi. First of all, perhaps I can just do some of the housekeeping. It's quite well. It's probably quite unusual to have housekeeping, I think, on a webinar. But all I was going to say was, firstly, in relation to questions, we'll deal with those at the end, and in relation to the feedback form, that will actually be posted in the chat box. Clearly, if there's any questions that we don't have time to deal with today, we can always provide emailed responses. I'll introduce myself. My name's Stuart Evans. I'm a legal director with Anthony Collins Solicitors, and I lead on planning at the firm. Could I have the next slide, Billy, please? Helping me and supporting me today will be Billy Richards, trainee lawyer with Anthony Collins Solicitors, and he's recently left the planning seat. So the webinar this afternoon is basically about the changes to the use classes order, and also to Billy will also deal with the recent challenge to the government's changes. So the Prime Minister used the wonderful words build, build, build. That always reminds me of what Prime Minister Blair said with education, 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 but we're looking at build, build, build. Could we go on to the next slide, please, Billy? In the press release entitled A New Deal for Britain, the Prime Minister set out basically the changes. So on the 30th of June 2020, Boris Johnson announced radical changes to the planning system. These included changes to the use classes order, as well as the introduction of additional permitted developments. Now, I'm sure most of you have actually seen these. Set against the backdrop of COVID-19 pandemic, which saw a lot of building work and development grind to a halt. It is hoped that these changes will increase flexibility in the use of buildings and make development easier. This was certainly the government's position. You see on this slide in the press release titled A New Deal for Britain, the Prime Minister set out more types of commercial uses having total flexibility to be repurposed through the reform of the use classes order. A wider range of commercial buildings will be allowed to change to residential use without the need for a planning application. Builders will no longer need a normal planning application to demolish and rebuild vacant and redundant residential and commercial buildings if they are rebuilt as homes. And property owners will be able to build additional space above their properties via a fast-track approval process, of course subject to neighbourhood consultation. So in the press release dated 30th of June 2020, titled A New Deal for Britain, Prime Minister Boris Johnson set out, amongst other things, a reform to the planning system, including, can we go to the next slide, Billy, please? So these changes, which are planned to come into effect by September, that is now passed, will both support the high street revival by allowing empty commercial properties to be quickly repurposed and reduce the pressure to build on greenfield land by brownfield develop and make brownfield development easier. Clearly, I think we've all seen the issues with the high street, and any assistance in improving the situation in the high street has to be welcomed. Could we go on to the next slide, Billy, please? So changes made to the use classes order, and this really deals with the the detail of what changes were made by the government. So the Town and Country Planning Use Classes Amendment England Regulations 2020 made changes to the use class order, and these took effect on the 1st of September 2020. The regulations introduced 3 new use classes. There's Class E, which is commercial, business and service, Class F1, which is learning and non-residential institutions, and F2, local community. Could we go on to the next slide, Billy, please? First of all, if we deal with what use Class E covers, and I think this is one of the widest things I've actually ever seen. It's quite amazing what it does cover. So retail, food, financial services, indoor sport and fitness, medical health services, nurseries, light industry, and other services appropriate to commercial business or service locality. Can we go on to the next slide, please, Billy? So use class F1 absorbs the remaining parts of use class D1 and covers the following things. That's non-residential educational uses, museum, art gallery, library, public hall, religious institutions, and also law courts. If we could go on to F2, Billy, please, now. So F2 absorbs part of A1 and D2, and it covers small corner shops, swimming pools, community halls, and outdoor recreational areas such as a skating rink. If we could move on, Billy, that would be good. If we move on to sui generis, basically the list of sui generis uses has been added to, which means a change from one to another would require planning permission if there is a material change of use. So the ones which have been added are pub, drinking establishments, hot food takeaways, live music venues, concert halls, bingo halls, and cinemas. So if I deal with these in summary now, so these new classes replace the former use classes and use classes A1, A2, A3, B1, and parts D1 and D2 now fall into the massive new Class E, which when I first looked at it, you could basically do absolutely anything in it. The remaining use classes within parts A and D of the original schedule on our sui generis uses. Class B2 remains in the new Schedule 1 in an amended form. Classes C1, C2, C2A, C3 and C4 remain unchanged. Up until the 31st of July 2021, the existing use class order will be retained for the purposes of permitted development rights. That's a pretty crucial date, actually. So there is that retention there. We could just move on, Billy, that would be helpful, please. So we're now going to have a look at additions to permitted development rights. So firstly, if we can have a look at additional two-storey flats. So the Town and Country Planning Permitted Development Miscellaneous Amendment England Coronavirus Regulations 2020 add an additional permitted development. So Class A allows up to 2 additional stories to be added to certain blocks of flats. So additional 2-storey flats, up to 2 additional stories of new dwelling houses immediately above the existing topmost story must be on a building that is a purpose-built block of flats. Building must be constructed after the 1st of July 1948 and before the 5th of March 2018. Clearly, there needs to be limitations, because otherwise I think most planners would have a complete horror. So the development is not permitted by Class A if the building is less than 2 stories in height, the additional stories constructed other than on a principal part of the building. New dwelling houses are not flats. The floor to ceiling height of the additional story is more than 3 meters in height, or more than the floor to ceiling height of any of the existing stories. There are additional limitations, so the development is not permitted by Class A if greater than 30 meters in height. Overall height of the roof would be greater than 7 meters higher than the highest part of the existing roof. And clearly, the land is of special scientific interest, it's listed, or there is a safety hazard. A detailed prior approval process with the council must also take place. And I'm sure a lot of you have now come across the process. Certainly a lot of the clients I'm dealing with are feeling their way with this process at the present time. But I think the detailed prior approval process is something which certainly some developers potentially forget about. So I think it is a matter of education. So if you could go on to the next slide, Billy, please. So here we're dealing with the additional two stories houses. So the Town and Country Planning General Permitted Development England Amendment number 2 Order 2020 had a new permitted development in relation to residential properties. So Class AA allows for the enlargement of a dwelling house by the construction of either A, up to 2 additional stories where the existing dwelling house consists of 2 or more stories, or 1 additional story where the existing dwelling house consists of 1 story. So the houses must be constructed after the, could you just go to the slide, Billy, please? So the house must be constructed after the 1st of July 1948 and before the 28th of October 2018. It doesn't apply to properties where additional stories have already been added to the original house. Could we move on, Billy, please? So clearly there are limitations, I'm pleased to say. So the development is not permitted by Class AA. Dwelling house is not detached, and following the development, the highest part of the roof would exceed by more than 3.5 meters. In case of a semi-detached house, the height of the highest part of the roof of the building, with which it shares a party wall, or as the case may be, which has a main wall adjoining its main wall, or in the case of a terraced house, the height of the highest part of the roof of every other building in the row in which it is situated. So the dwelling house is on the limitations are, the dwelling house is on a site of special scientific interest. After development, the height of the highest part of the roof would exceed 18 meters. Limitations, houses that are not detached. Following development, the highest part of the roof would exceed the height of the existing roof by 3.5 meters if 1 story, or 7 meters if more than one story. So clearly, there's quite a minefield developing here that requires careful interpretation. So in relation to the next issue, so we're looking at the limitations. Various conditions must be met. Additional story constructed other than on a principal part of the existing dwelling house. Limitations, houses that are not detached. Floor to ceiling height of additional story would exceed 3 meters or floor to ceiling height of principal parts of the existing dwelling house. So in relation to this, the materials used in the exterior work must be of a similar appearance to those used in the construction of the exterior of the existing dwelling house. The development must not include a window in any wall or roof slope forming a side elevation of the dwelling house. That's common sense. The roof pitch of the principal part of the dwelling house following the development must be the same as the roof pitch of the existing dwelling house. And following the development, the dwelling house must be used as a dwelling house within the meaning of Class C3 of the Schedule to the Use Classes Orders, and for no other purpose, except to the extent that the other purpose is ancillary to the primary use as a dwelling house. If you could move on to the next slide, please, Billy. So clearly, a detailed prior approval process with the council must also take place. Billy, I think I'm handing over to you now. Thank you.
Yes, hi, on to me now. So now we have the additional class ZA. So this was introduced in the Town and Country Planning General Permitted Development England Amendment number 3 order, which is quite a mouthful to say. This was introduced on the 31st of August 2020, and this allows the demolition of certain vacant buildings and their replacement with a new residential building. So this permitted development applies to single purpose-built detached blocks of flats, any other single detached buildings comprising premises that are established for either an office use within Class B1A, research and development falling within Class B1B, and an industrial process falling in within Class B1C. So the replacement building must be a purpose-built detached block of flats, be a purpose-built dwelling house, and the old building must have been vacant for a period of at least 6 months, and that's immediately prior to the date of the application for prior approval. And as with the other permitted development rights, there are limitations. So the first of which applies where the footprint of the old building exceeds 1,000 square meters. If that's the case, then the Class ZA permitted development right will not apply. If the height of the highest part of the roof of the old building above the ground level is greater than 80 meters, similarly it will not apply. If the building is constructed after the 31st of December 1989, if the building's of special scientific interest, if it's listed, and again that's whether the building itself is listed or even if part of the building is listed, if there's a safety hazard, and if there's an agricultural tenancy in place, then you will need the express consent of both the landlord and the tenant. Of course, limitations once again don't stop there. So we also have if the building is now nearer to the highway than it was before, then the class will not apply. If the footprint of the new building is outside of the footprint of the old building, now as the previous footprint needs to be no larger than 1,000 square meters, that's naturally a bit of a limitation on the size of the new building too. The old building has been rendered unsafe or uninhabitable by action or inaction of a person with an interest in the land, then the class will not apply. And the class will also not apply if the height of the building would exceed 7 meters above the height of the old building or 18 meters. And finally, for the limitations, the class will not apply where the new building is more than 2 stories more than the previous building. If the height of any plant on the roof of the new building, as measured from the lowest surface of that roof, would be greater than the height of any existing plant as measured from the lowest surface of the existing roof, but on the principal part of the old building. The new building has more stories than the old building, and the floor to ceiling height of any additional story in the new building measured internally, the greater than the lower of either the floor to ceiling height, which is measured internally, of any story in the old building, or 3 meters. And once again, we have that detailed prior approval process, which must take place with the council. So the Climate Action Campaign Group, Rights Community Action, as I'm sure many of you know, they applied for a judicial review of the new use classes and also the permitted development rights. So for anyone here that's unaware, a judicial review is an examination by the courts of the decisions made by any public body, and this is to ensure they act fairly and lawfully. So what were the grounds of RCA's judicial review? So they had 3 grounds. Firstly, they alleged that the Secretary of State for Homes, so Robert Jenrick, they alleged that the government failed to conduct a strategic environmental assessment of the changes, which is required under the 2004 Environmental Assessment of Plans and Programmes Regulations. So just to quickly go over what the court said, they applied a 4-point test. Excuse me. So the first of the points was that the measures must have been prepared and adopted by a national authority, which they were, so that one was met. They need to be required in the sense of being regulated by the Town and Country Planning Act 1990. This one was also met, but it was the third point where the court found that this wasn't met, so it must set the framework. So it needs to be the criteria for future developments and consents and projects. On this point, the court held that the challenge failed, as this just set out permitted development rights. It didn't set out any sort of framework or criteria that an authority would use in considering other applications. The next ground for the judicial review was the breach of the public sector equality duty. Quite simply for here, the court held that there was no basis, there was no proper or realistic basis on which it could be said the government had failed in this duty. And the third ground for judicial review was that there was a failure to account for consultation responses and other considerations. So here it was said that the Secretary of State for Housing, Communities and Local Government did depart from responses that they had already received, but the court argued that the court found that this was to stimulate the process of development in the circumstances of economic urgency. So it was to stimulate the economy in relation to the impact of COVID-19, which I'm sure everyone here will know has had a massive impact both on our lives and the way the country, and in a lot of ways the whole world, is currently operating. So what does this mean? What happens now? So RCA have confirmed that they are seeking permission to appeal. If they get permission, then we could be looking at this whole question of whether or not these development rights will remain in law. We could be looking at that question all over again. But for now, these new use classes and permitted development rights they've already been implemented in law and they will remain in force. So this means that all these new permitted development rights and the use classes can be used. But the question still remains that what happens if RCA are allowed to appeal, and what happens if RCA are successful on appeal? So we could be faced with a situation where later down the line the appeal is allowed, RCA are successful, and the changes to the use classes and the permitted developments are set aside. So we could then be in a position where, you know, there's a series of leases that refer to a use class. There have been planning permissions granted that refer to a now defunct use class. There could be buildings that have already been demolished using one of the new permitted development rights. So really, care should be taken for the time being when deciding whether or not to use any of the new development rights or any of the new use classes, simply until we find out what happens next. So I see we have had a few questions sent through to us. If anyone does have any further questions, there is a questions box that you can type your question into through GoToWebinar. So if you do have any questions, do feel free to send those through to us. But Stuart, we have had one question. Have we experience or knowledge of the new amendment stating it is not a development to change between C-class groups? Stuart, could you perhaps take that question?
We've had no direct questions about that yet in dealing with our daily work. But I think certainly the C class groups basically stay in place anyway, because clearly I think it's particularly the C class groups that the government will be particularly concerned about, particularly when it relates to HMOs and things of that nature. I think there's an awful lot of pressure from their own MPs and also from local sort of Conservative councillors, particularly in some of the university towns. I think we've also gone through the changes to Class B as well. A lot of those have basically morphed into Class E, which, as I said when I was speaking, is quite an incongruous use class order. So to be honest, Ryan, you know, it'd be good to talk a bit further about it tomorrow. I know we're talking tomorrow, but you know, that's my sort of take on the two different use class orders you've actually referred to. So the next question is from Lorraine Taylor. Now, in relation to the time frame for the appeal, we don't know at the moment, and I know the courts are clearly struggling. So the High Court decision was about 3 or 4 weeks ago. But what I will do, and I have been checking over the last few days to see whether any appeal has been made, and I'm not aware of anything yet. But what I will do, I will post a tweet or something like that once I have any further information on that, certainly. Okay. Are there any other questions, guys, at all? No? We do like questions. But, you know, very happy for you to email us or do anything like that, and for any additional clarification. Very happy to do that. Thank you. So if you'd like to leave any comments you have on the training session with the assessment forms that you'll find in the chat room, that would be greatly appreciated. Thank you. Right. Any additional questions? No? Well, thank you everybody for your time this afternoon. This is an extremely interesting area of the law, which I think becomes more and more complex every time the government tampers with it. And it only has to be seen as to whether the changes which are being made will actually sort of improve things like will assist in the sort of the regeneration of our high streets. It's also going to be interesting to see where we're also going with the legal challenge, the judicial review to the changes made by government. But I think, as Billy said when he was talking about the changes, I think we've got to be particularly careful when we're dealing with leasehold properties, and we do need to put some caveats into the wording, etc. Basically to ensure that we deal with all changes, and also just to double check that we also deal with a situation where the legislation is actually quashed by the Court of Appeal. As I said, I will certainly keep an eye on the situation with the court proceedings, and I will put some notification through the website. All right, thank you very much for your time this afternoon. Thank you.